So just to clarify that. We're now call 126-478 in the matter of Sarah E. Johnson. I know only a few seconds have really passed since Mr. Shima called the docket. Ms. Johnson made no appearance then, but one more time, I will ask if Sarah Johnson's in the courtroom. Seeing no response, Mr. Vogelsberg, whenever you're ready, you may begin.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Since Ms. Johnson hasn't appeared, I will not be requesting rebuttal time. This is original action in attorney discipline involving respondent Sarah E. Johnson. Ms. Johnson was admitted to the Kansas bar in September 2001. Ms. Johnson's law license was administratively suspended in September of 2021 due to her failure to pay for the annual registration fee. Her license has remained suspended since that time. The ODA filed its formal complaint against Ms. Johnson on February 17th of this year, alleging that Ms. Johnson committed rule violations in 6 separate disciplinary complaints that were filed against her. Pursuant to Rule 215A, the ODA mailed the formal complaint and notice of hearing by certified mail to Ms. Johnson's registered business and residential addresses. The mailing sent to the business address was returned to the ODA on March 6th with the notation returned to sender, unable to forward. The certified mailing sent to Ms. Johnson's residential address was returned to the ODA on April 6th with a notation that it had been returned as unclaimed. Additionally, the ODA sent copies of the formal complaint and notice of hearing by regular mail and by email to Ms. Johnson. The ODA did not receive any indication that those mailings were not delivered to her. Ms. Johnson ultimately failed to file an answer to the formal complaint, and she failed to appear for the disciplinary hearing that was on April 18th. Highly summarized, the evidence presented at the hearing established that based on the timing of when the ODA started receiving disciplinary complaints against Ms. Johnson sometime in early 2021, Ms. Johnson abandoned her law practice, which was focused on doing criminal appellate work. She abandoned numerous retained and appointed clients, which resulted in the 6 disciplinary complaints being filed against her. After the hearing, the panel issued its final hearing report on June 5th, concluding that Ms. Johnson violated 1.3 diligence, 1.4 communication, 1.16 termination of representation, 3.4C knowingly disobeying an obligation under the rules of a tribunal, 8.1B knowingly failing to respond to a lawful demand for information in connection with a disciplinary matter, 8.4D conduct prejudicial to the administration of justice, and Supreme Court Rule 210, duty to timely respond to a request for information. At the conclusion of the hearing, the ODA recommended that Ms. Johnson's license be suspended for 30 months and that she be required to undergo a reinstatement hearing under Rule 232. The hearing panel recommended that Ms. Johnson be indefinitely suspended. This case was docketed with this court on June 16th. That same day, the clerk of the appellate court mailed notice to Ms. Johnson by certified mail to her registered residential and business addresses, notifying her that she had 21 days to file exceptions to the hearing panel's report. Ms. Johnson never filed exceptions, so pursuant to Supreme Court Rule 228G, the findings of fact and conclusions of law are deemed admitted by Ms. Johnson, and so the only issue before the court today is what sanction to impose upon Ms. Johnson.
Let me ask you, when you sent those to her, is there proof of receipt, or did you also get notice that they were undeliverable?
The clerk's office sent those, and due to the recent security, I'm not able to access the return receipts on those.
Got it. Thank you.
I would also mention that on September 14th, this case was scheduled for today's oral argument. And on September 19th, the ODA sent letters by regular mail to Ms. Johnson's registered residential and business addresses and emailed letters to her registered email address, plus also a personal email address that we had discovered during the course of the investigation. The letter notified Ms. Johnson about today's oral argument. The letter mailed to Ms. Johnson's business address was returned to the ODA as undeliverable on September 28th of 2023. The letter mailed to her residential address was never returned, so presumably that letter was delivered. And then also the ODA did not receive any bounce back notifications regarding the 2 sent out regarding today's oral argument. So presumably Ms. Johnson has received notice of today's hearing. Given the rule violations that were found by the hearing panel and Ms. Johnson's failure to appear today, the ODA will ask the court to adopt the hearing panel's recommendation of indefinite suspension. This court has recognized in prior cases, including N. Ray Barker, 302 Can 156. It's a 2015 case. That a respondent's failure to appear for oral argument can be considered an aggravating factor, which may warrant imposing a sanction greater than that recommended by the ODA or the panel. The ODA would ask the court to apply Barker and impose an indefinite suspension in this case. Unless the members of the court have any questions for me, I would waive the remainder of my time.
Was there some other information or evidence suggesting that at least the respondent was aware of the investigation? I thought I read that there was at least some communication, some indication of maybe some ADHD or whatever, but some interaction. Was that with your office and Ms. Johnson or the investigators?
During, the investigation, she had sent a response by email on July 12th of 2021 regarding the first 3 complaints that were filed against her, specifically in her response concerning DA 13689, which was a complaint that was actually submitted by Mr. Shima regarding her conduct in 3 cases that she was appointed to represent defendants before this court. She had identified issues, mental health issues, as contributing to her inability to comply with the deadlines established by the court.
Thank you, Mr. Vogelsberg.
Thank you.
Court will take this matter under advisement.